So my presentation for today is about GDPR in Romania, and I raise the question if GDPR is still a toddler today, even after almost 3 years since it was regulated by the European Union. So I want to talk about this subject in this conference for 6 main reasons. First of all, the General Data Protection Regulation will turn 3 years old on May 25th, 2021, and its entry into force in 2018 created an effervescence among public authorities, local entrepreneurs, and legal practitioners, and created many new jobs and specializations. However, GDPR hasn't reached maturity yet, being still misunderstood, poorly applied, or eluded, even today, by many European companies, by public authorities, and in particular by web administrators. It doesn't matter in which field of activity we operate in, businesses are partially or totally online nowadays, and GDPR is omnipresent in every sector of activity. The weaknesses of the GDPR policy are mostly exposed in the online environment and were augmented by the current pandemics. That changes the way we interact, changes the way we work and engage in social activities. The digital transformation tendency and current advancements, mostly in the medical and in the artificial intelligence fields, for example, the development of messenger RNA vaccines, in robotics, in the development of autonomous vehicles, in the Internet of Things, etc., they depend on collecting large sets of data. So they often raise questions regarding data mining. They raise questions about confidentiality, about data preservation, about analysis, and the protection of intellectual property rights. As what concerns the subject matter of this conference, GDPR, I believe, is a breakthrough regulation when protecting intellectual property rights, especially in an online environment, because according to the preamble of the European regulation in force, the right of access to personal data should not adversely affect the rights or freedoms of others, including trade secrets or intellectual property, and in particular, the copyright protecting the software. Last but not least, I'm a Romanian lawyer, currently specialized in domestic and international commercial law affairs, and my theoretical and practical training is tangential to intellectual property rights. So I want to share with you some of my experience and to present a brief retrospective of last year as concerns GDPR matter, especially in Romania. As for general remarks about GDPR, as you may already know, GDPR is directly applicable in all entities within the EU, including in Romania and in Poland, even to websites based in other countries which process personal data of visitors located in the European Union. Many European countries have adopted additional data protection legislation in order to implement the measures imposed by the GDPR. For instance, in Romania, we have law number 190/2018. However, in the USA, there is nothing close to the GDPR at the federal level. However, there are certain US states which began to legislate locally with the intention to protect privacy and consumer rights, such as the California Consumer Privacy Act, also known as CCPA, effective from January the 1st, 2020, or the less ambitious Nevada Privacy Law from 2019. The GDPR, in line with other regulations, such as the European Charter of Fundamental Rights, considers personal data as exclusive rights of the individuals over which in principle no property rights could be exercised. The regulations refers to the basic rights and freedoms, and in particular the right to the protection of personal data, therefore providing the definition of the right separate from the definition of property. This view is not necessarily shared in the US, maybe except California, that has, as I said before, the CCPA Act. In Europe, any breach of the GDPR regulations is an illegitimate act and may be fined up to 20 million euros or 4% of the company's global yearly turnover of the preceding financial year, whichever is higher. And it may be imposed in Romania by the supervisory authority, which is the National Supervisory Authority for Personal Data Processing. As for the definition of personal data under the scope of GDPR, personal data means any information related to an identified or identifiable natural person, or so-called data subject. Mainly, an identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity or that natural person. There are also special categories of personal data, so-called sensitive data. As a matter of principle, each of us who owns a business or an NGO or runs a public authority or university or simply manages a website must consider all information that he or she collects from his or her employees or website guests as personal data. Otherwise, he or she could run the risk of not handling the collected data with the necessary precautions, and the fines may be really high, as I said before, even if there is no minimum threshold. Also, I strongly recommend caution with handling such sensitive data, especially in the nowadays politically correctness environment. Processing of personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union memberships, or genetic data, biometric data for the purpose of uniquely identifying a natural person, or data concerning health, or data concerning a natural person's sex life or sexual orientation shall be prohibited. Because our time today is short and I don't want to bore the audience with merely theoretical facts about data protection principles that maybe you already heard and people privacy rights that other speakers will talk about, I like to discuss, however, an interesting retrospective of the year 2020 in the field of personal data protection. As for sanctions across Europe, in 2020, the European countries reported a number of 324 administrative fines and several administrative warnings that were imposed on personal data controllers by the competent authorities of different European countries following investigations completed between January and December. The sanctions concern the following types of GDPR infringements. For instance, failure to take the necessary measures to ensure data security and confidentiality, which has led to security incidents, such as the case of AOK, an operated sanction by the German Data Protection Authority, with an administrative fine of 1.24 million euros for failing to implement technical measures and appropriate organizational arrangements to ensure that only data subjects who have given their consent to receive marketing emails receive such emails. Thus, a number of 500 data subjects located in the operator's database received marketing emails, although they did not express their consent to receive such communications. Also, for non-compliance with the obligation to notify security incidents, the Data Protection Authority of Ireland announced that following an investigation completing at the level of the operator Twitter International Company, it ordered its sanction with an administrative fine in the amount of 450,000 euros. The fine was applied because the operator did not notify the security incident within 72 hours from the date of notification, nor it did properly document the measures taken. Also, in Italy, Team SPA was sanctioned by the Data Protection Authority, which it imposed an administrative fine in the amount of 27,800 million euros for sending marketing emails in the absence of the consent of the data subjects or despite their opposition to receiving such communications. And for violating the rights of data subjects, also the Italian Data Protection Authority announced that following an investigation completed at the level of the operator of MAPEI SPA, sanctioned this operator with an administrative fine of 15,000 euros, as among other things, it violated the provisions of the GDPR because the controller did not respond to a request for access to personal data from a former employee. In Romania, 26 fines and several administrative warnings were imposed to personal data operators by the local authority for failure to take the necessary measures to ensure data security and confidentiality, for non-compliance with the principles regarding the processing of personal data, for non-compliance with the obligation to cooperate with the authority, for data processing in the absence of a legal basis, and for non-compliance with the rights of data subjects. The fines, the largest fine was 100,000 euros applied to a bank, to Banca Transilvania. Also, as a premiere, in 2020, two public authorities were sanctioned by the local authority, the national authority, namely local police from Sector 4 Bucharest for processing personal data such as images, voices through portable audio-video surveillance used by the staff of the department in missions and activities carried out on the ground, and the local police of Cluj-Napoca city processing personal data through portable audio-video systems of the type body-worn camera used by the local police officers in the exercise of their duties. Some of the operators that I indicated above have been sanctioned for cumulative non-compliance with several of the obligations set out in the above lines. As conclusions, GDPR, I believe, is still little unknown to the general public, both in Romania and abroad. And not only small and medium enterprises, but also large companies continue to break the European rules on personal data protection, often unwittingly. That's why I want to raise awareness about this issue and to show you the importance of having a good GDPR policy and good confidentiality policies implemented, especially in the online environment. And in order to avoid the sanction that may arise in the case of a GDPR violation, I conclude with a few recommendations, such as the implementation of all technical and organizational measures to ensure the confidentiality and security of personal data. This also includes taking the necessary measures to ensure that marketing emails are sent exclusively to persons who have not exercised their right to object to such communication. Also, a swift response to all requests from the competent data protection authority and comply with the measures ordered by that authority, including promptly submitting the requested information in the event of an audit or investigation conducted in respect of your company. An immediate response to the requests of data subjects and ensuring the exercise of the rights of such persons, provided that it is ensured in accordance with the provision of the GDPR identity between the applicant and the data subject in respect of whom the rights are exercised or the information is requested. Notifying the competent data protection authority of any security breach or incident that poses a risk to the rights and freedoms of the data subjects affected within 72 hours from the date on which it became aware of the incident and describe the measure taken in respect of that event. And last but not least, ensuring that they process personal data only if one of the 6 requirements provided by the GDPR is validated, namely consent of the data subject, performance of a contract, respectively steps to conclude a contract, fulfillment of a legal obligation, protection of the vital interests of a task that serves the public interest, and legitimate interest of the operator, all to be done in compliance with the principles set out in the GDPR regulation. Thank you for your time.